Hello and welcome to another video from Lawsisto. I am Ishika, and in this video we're going to be discussing the new guidelines laid down by the Supreme Court of India regarding the wife's right to claim maintenance and alimony. Recent judgment, the Supreme Court of India ruled that an abandoned wife and children will be entitled to maintenance from the date that she applies for it in a court of law. The Parliament and the courts have persistently enacted legislations to give women and children better rights. The Article 15(3) of the Constitution, which states nothing in this article shall prevent the state from making any special provisions for women and children, read together with Article 39, which directs state policy towards equal pay and opportunities for both men and women and protecting the health of women and children, are two key constitutional safeguards provided for by the Constitution of India to safeguard the rights of women and children. In November 2020, the Supreme Court framed guidelines pertaining to payment of maintenance in matrimonial matters and ensured uniformity in taking the decision. The Constitution guarantees protection to women and children under Article 15(3) of the Constitution, reinforced by Article 39, envisages a positive role for the state in fostering a change towards the empowerment of women. The need for the empowerment of women has led to the enactment of various legislations from time to time. One such issue regarding women which has required framing of statutory legislations has been that of maintenance. The legislations which have been framed on the issue of maintenance are the Special Marriage Act 1954, Section 125 of the CRPC 1973, and the Protection of Women from Domestic Violence Act 2005, which provide a statutory remedy for women irrespective of the religious community they belong to and apart from the personal laws applicable to various religions. The court laid down that while women can make a claim for alimony under different laws, including the Protection for Women from Domestic Violence Act 2005, Section 125 of the CRPC, or the Hindu Marriage Act 1955, it would be inequitable to direct the husband to pay maintenance under each of the proceedings, urging civil and family courts to take note of previous settlements, perhaps keeping in mind the vastness of India and its iniquities. The court also added how an order of decree or maintenance may be enforced under various laws and Section 128 of the CRPC. Let's talk a little about the case that led to this judgment. The recent guidelines were issued by court in Indu versus Rajneesh and others, where proceedings for payment of interim maintenance under Section 125 of the CRPC were pending between the parties for over 7 years. The husband had moved to the Supreme Court challenging the High Court's decision to uphold the trial court's order awarding interim maintenance to his wife and minor son. A division bench of the top court, comprising Justices Indu Malhotra and Subhash Reddy, considered it appropriate to refer the matter for mediation and arrive at a settlement. On October 8, 2020, the court was informed that the mediation had failed. The husband appeared before the court and made an oral statement that he did not have the financial means to comply with the order for maintenance payable to his wife and had to borrow from his father to do so. He stated that he had paid for the maintenance awarded to his son and would continue to do so. Both parties filed their written submissions. Considering that the proceedings for payment of the interim maintenance had been pending for over 7 years, the court directed the family court to decide the substantive application under Section 125 of CRPC. The court also noted that the wife was constrained to move successive applications for enforcement. There are different statutes and enactments that provide an independent and distinct remedy framed with a specific object and purpose. In spite of timeframes being prescribed by various statutes for disposal of interim applications, in a vast majority of cases, they are not disposed of within the timeframe prescribed. So, what was the need of such a judgment? There were three needs for a judgment like this. Usually, maintenance cases have to be settled within 60 days, but they usually take years in reality owing to legal loopholes. Second, The top court said that women deserted by husbands are left in dire straits, often reduced destitution for lack of means to sustain themselves and their children. Moreover, despite a plethora of maintenance laws, women were left empty handed for years, struggling to make ends meet after a bad marriage. The court therefore felt the need to frame guidelines on the issue which would also cover overlapping jurisdiction under different enactments for payment of maintenance, payment of interim maintenance, the criteria for determining the quantum of maintenance, the date from which the maintenance is to be awarded, and enforcement of the orders of maintenance. Now let us discuss some of these factors in detail. The direction of overlapping jurisdiction. To avoid conflicting orders being passed in different proceedings, the court directed that in a subsequent maintenance proceeding, the applicant will disclose the previous maintenance proceedings and the orders passed therein. This will allow the court to take into consideration the maintenance already awarded and grant an adjustment to the said amount. If the order passed in the previous proceeding requires any modification, the party would be required to move the concerned court in the previous proceeding. Secondly, the guidelines regarding the payment of interim maintenance. The court finds it necessary to lay down a procedure to streamline the proceedings, since a dependent wife who has no other source of income has to take the recourse of borrowing money from her parents or relatives to sustain herself and her minor children until she receives maintenance. The Family Court, in compliance with the mandate of Section 9 of the Family Courts Act 1984, must make an endeavour for settlement of disputes. For this, Section 6 provides that the state government shall, in consultance with the High Court, make a provision for counsellors to assist a family court in the discourse of its functions. Marriage counsellors need to be appointed in every family court to help in the process of settlement. If the proceedings for the settlement are unsuccessful, the family court will proceed with the matter on merit. On the other hand, on the basis of the pleadings filed by both the parties and the affidavits of disclosure, the court would be in position to make an objective assessment of the approximate amount to be awarded to the maintenance at the interim stage. Thirdly, the criteria for determining the quantum of maintenance. The objective of granting interim or permanent alimony is to ensure that the dependent spouse is not reduced to destitution on account of failure of a marriage and not as a punishment for the other spouse. There is no straitjacket formula for fixing the quantum of maintenance to be awarded. The factors which would weigh with the court, such as the status of the parties and if there are any children, the educational qualifications of the wife, her source of income, etc. Fourthly, the guidelines regarding the date from which the maintenance is to be awarded. There is no provision in the Hindu Marriage Act with respect to the date from which the maintenance is to be awarded. Similarly, Section 12 of the Domestic Violence Act does not provide for the date from which the maintenance is to be awarded. Section 125(2) CRPC is the only statutory provision which provides for the magistrate may award maintenance either from the date of the order or from the date of the application. The view that maintenance should be granted from the date of application is based on the rationale that the primary object of maintenance laws is to protect a deserted wife and her dependent children from destitution. If maintenance is not paid from the date of application, the party seeking it would be deprived of sustenance owing to the time taken for disposal of the application, which often runs into several years.